We've got some wonderful speakers here, and I want to go ahead and get started. Some of you are students, I'm sure, but for those of you I don't know, I'm Professor Deborah Pearlstein. I teach international law and constitutional law here at Cardozo Law School. And I am also co-director of our Floersheimer Center for Constitutional Democracy, which, especially for students who are new to Cardozo, is a center at the law school that hosts events and workshops for scholars and students and practitioners in law that are working on issues that are related to constitutional democracy broadly conceived. Today is the first of two events we're doing here at the Floersheimer Center around the 20th anniversary of the attacks of 9/11 that are reflecting on how the past 20 years of war has shaped the law and lawyering constraining U.S. counterterrorism, U.S. government counterterrorism efforts in the United States and abroad. The issues, I think, have never been more relevant. I want to make sure everybody's got their phones or screens on mute. The issues, I think, have never been more relevant than they are today, and that's for a lot of reasons. For one thing, obviously, we've all just witnessed the collapse of the Afghanistan government after 20 years, the takeover of the Taliban, and with it, concerns of a rise of renewed terrorist threats of the kind we were facing on 9/11 and after, but also the statement by the Biden administration that we will see some sort of, as they put it, over the horizon or form of counterterrorism operations continue globally. What those will look like, how many countries those will continue to take place in, are major questions we still face. In the meantime, there are a set of legacy issues from the attacks of 9/11 that are still very actively litigated in federal courts in the United States and very actively debated in Capitol Hill. Not only are there still detainees held at Guantanamo Bay, there are still military commission trials pending for some of the folks we believe are most responsible for the attacks of 9/11, and a very active debate on Capitol Hill about what kind of war authorization or authorizations a president should have going forward. And in the meantime, we've seen in recent years, especially, the rise of a threat of domestic terrorism, most dramatically on January 6th of this year, driven substantially by white supremacist extremists here domestically, and the government began to embark on a new program of domestic counterterrorism efforts to combat it. And then finally, we're at this delicate moment 20 years on, as I am reminded daily, where events that at one point seemed extremely current and pressing and familiar are now passing from the lens of current events for a whole new generation into the much fuzzier lens of history. And the question for all of us is, what do we highlight from these years? What do we remember? How do we characterize them? And this is a delicate undertaking for every historical event, and certainly here for this. Our focus today, having said all of that about how much ongoing importance these issues still presents, is on the impact of U.S. counterterrorism efforts on international law in particular. And we have two extraordinary panelists who I'm so grateful to have with us today to help us think through them. Let me introduce them briefly, and you'll be able to find their full bios online. They're both extraordinary. I commend just their bios to your attention to read, but maybe for just present contextual purposes, let me first introduce John Bellinger, who is currently a partner at Arnold & Porter. He leads their global law and public policy practice. Before that, though, among his positions in government, John Bellinger was general counsel at the National Security Council in the White House, I think on 9/11, is that right, John? Yeah, and then several years into the administration moves over to be State Department legal advisor at the U.S. Department of State, which is the senior lawyer for the United States at the State Department. Tess Bridgeman, who is now co-editor-in-chief of Just Security, which is a wonderful blog, a legal blog of people who are experts and scholars and practitioners who write in these areas. But before she joined Just Security, she served as associate counsel to the president of the White House, and then deputy legal advisor at the National Security Council, also at the White House. Before that, I learned from reading her bio, she had also served in the State Department's legal advisor office. John Bellinger served in these positions during the Bush administration. Tess Bridgeman served in these positions during the Obama administration. And they both have a wealth of experience that we can't begin to tap in these hours. But in this 1 hour, that is to say, in the interest of promoting a conversation, though, what I'm going to do is pose questions to each of them, and sometimes to both of them. And I will encourage and have encouraged each of them to jump in and comment on what the other says or what I say, if and when they wish. If you have questions along the way, and I hope you will, there's a Q&A button, should be at the bottom of your screens. Please write your questions in the Q&A. I will do my best to get to them toward the end of our period of time, and pose them to our panelists for you. So don't hesitate to pose questions, and I hope to get to some of them at least. Okay, so with that lengthy introduction, let me start, I think, with actually just the latest, because there's a lot going on right now. John, I know that you've been doing some work with Afghanistan evacuees, folks who are still have been trying to, and are still trying to leave Afghanistan after the collapse of the government there. Can you say just a little bit about what that has involved as a lawyer, what your work has involved, and then if you can give us some sense, obviously there's been this extraordinary airlift, 124,000 people or so taken out in this airlift led by the United States of Afghanistan, including US nationals, but many others. Is there hope remaining going forward that these evacuations, these refugees will continue to be able to leave Afghanistan?
Thanks, Deborah, and it's great to be with you and Tess, both of whom I know well. Always accept Deborah's invitations. I was on a panel earlier this year that Tess got to interview me. So I think as this comes full circle, I get to be the moderator next time and ask you two questions. But for the students, you all know well, I hope, how blessed you are to have Deborah Pearlstein as your professor. So just quickly, and we'll come back to this, of course, it's sort of head spinning for me because I spent the spring, summer, and fall of 2001 in the White House before day of the 9/11 attacks, then the aftermath, and then the invasion of Afghanistan, in which we first, pre-9/11, watched the Taliban and Al-Qaeda training camps in Afghanistan. We knew they were up to no good. Then in the invasion, pushed out the Taliban and Al-Qaeda, and now we've come full circle, which is just in 20 years is head spinning. And we'll talk about what that means. Right now, as part of my practice in Northern Reporter, we have, as many of you all will have in your futures, active pro bono practices where we provide free legal services to those in need. And so I, as a former government official, have been getting lots of calls for all kinds of different assistance. You know, can you let the State Department know that this family needs to be rescued in Afghanistan? Can you get out these reporters? I'll just mention this and then turn it over to Tess because it's been much in the news. One of my larger pro bono clients has been the American University in Afghanistan, which was set up largely with US government funding from USAID to educate really a new educated class of Afghans. Most of the preponderance, I think 55, 60% are women. And of course, that had been an enormous change in Afghanistan to have educated Afghan women. And it was something that we, of course, both administrations were very proud of, was to be funding the education of women in Afghanistan. And these, both men and women, would then go into professional jobs in government, in business and banking and academia. The Taliban had actually attacked the American University of Afghanistan a couple of years ago because they didn't like them educating women in Afghanistan. They killed a number of students. They took some professors hostage, but the students themselves were not to be deterred. But now, of course, the Taliban is in control. They've actually are using the American University in Afghanistan as one of their headquarters in Kabul. We've worked to evacuate the professors, the faculty, and now students who want to be evacuated. One of the things that I've been doing, I'll end with this because it's a legal issue, is of course the American University in Afghanistan's money, which is mostly U.S. government money, is in Afghan banks, which is now controlled by the Taliban. But here's the legal issue. To deal with the Taliban, to get the money out, we have to get a license from the US government. Tess is nodding because she's used to dealing with a part of our Treasury Department called the Office of Foreign Assets Control that imposes sanctions on foreign terrorist groups, including the Taliban. So I've been working to try to get the American University of Afghanistan's both their people and their money out of Afghanistan.
Thank you, and thank you for that work. Tess, you can obviously respond to any of that you wish or add, but let me ask you separately. I know you've been doing some work or been involved in some of the work on the Hill with war powers reform. Can you say just a little bit about what's driving that work, or what's behind that, and what it involves?
Sure, of course. Just also want to reiterate my thanks for the invitation. It's always great to talk with you, and of course with John, and to hear your insights both on what's going on now and when you served. You know, I think it's an interesting time for us to be talking about war powers and AUMF reform because of the intense focus both on, of course, the 9/11 anniversary, but also with the withdrawal from Afghanistan. But these conversations have been going on, of course, well prior to these more recent events. So you've seen, I think, an interest in AUMF reform for almost a decade now.
And can you say just a word about what the AUMF is?
Of course. Sorry. Yes, we can start at the very beginning, a very good place to start. So John should really be telling the story of how the AUMF came to be, but I'll give you the short version.
I'll ask him to tell that in a minute. So.
I'll give you the short version right now for the purposes of responding to your question, which is that's the authorization for use of military force against al-Qaeda and the Taliban, who are described but not named in that authorization that was passed by Congress in the days after 9/11, went on to be the legal basis, not just for the war in Afghanistan, but for many other counterterrorism operations around the globe. For now, 5 presidents in, we're looking at or terms in, we're looking at operations not just in Afghanistan, but in Iraq, in Syria, in Yemen, in Somalia, in Libya, the list goes on. And that authorization has, I think, by all accounts, been stretched beyond what Congress could possibly have intended right in the immediate aftermath of 9/11 to encompass not only places where it wasn't anticipated the United States might be fighting, but groups that didn't exist on 9/11, like ISIS, or the others I just mentioned, Al-Shabaab, AQAP. So the question of how Congress can get its arms around the conflict the executive branch has been fighting under the purported authority that Congress gave it right after 9/11 has been a live one since well before Biden was elected president, well before Biden decided to withdraw US forces from Afghanistan, and of course, well before this 20th anniversary remembrance that's on all of our minds right now. And I think you've seen at the same time, a separate but related set of questions around the balance of powers between the executive branch and Congress more broadly in terms of how the war powers provided in our Constitution are exercised, right? So Congress, of course, is given the power to declare war in the US Constitution right there in Article 1, along with a host of other war-making powers and other national security related powers. It was really the intent of the founders to put not just making decisions about going to war, but decisions adjacent to that could slide the US into war, right, all into Congress's hands. The president was just the commander-in-chief of the armed naval forces or the militias when called into service. And that was more of an administrative role that the executive had to play as the implementer of the law, but it wasn't nearly the kind of talismanic thing we think about today when you hear commander-in-chief authority. So the debates about how the executive branch's use of military force in instances when Congress has not authorized it. The debates about the contours of that power go back to the founding, but in modern times, what we see is ever and ever greater uses of that authority by the executive without congressional authorization, and then Congress being less and less able to claw that back, to tell the president to withdraw forces or to stop them from, stop hostilities from commencing in the first place. The War Powers Act of 1973 was one major landmark attempt by Congress to kind of reset the balance of power between the political branches. Following right after the Vietnam War, it's enacted over President Nixon's veto. And it was intended to not only shed light and give, transparency, provide notice to Congress of when the president was deploying troops that were not pursuant to statutory authorization, but also to give real teeth to Congress, a real enforcement mechanism to Congress to be able to say, if the president has deployed forces into hostilities or situations where it looks like hostilities might be imminent, that Congress can force the president to terminate those deployments, to bring the troops home. For a variety of reasons we can get into in our discussions, that enforcement mechanism didn't pan out. And to make a very long story short, and again, we can get into this later if you'd like, the mechanism that was intended to allow Congress by a simple majority of both houses to get the president to bring troops home turned into the need for a supermajority in both houses to stop the president from using forces without congressional authorization. That, based on political realities and the way that these situations play out in real conflicts, has meant that in practice we've never had a situation where the War Powers Resolution has worked to its intended effect. Even though in two instances in the Trump administration, Congress did pass joint resolutions pursuant to these expedited procedures the War Powers Resolution gives it, to tell President Trump in both of those instances to take troops out of situations of imminent hostilities in Iran and out of hostilities in Yemen, in support of the Saudi-led coalition. So you've had members of Congress trying to use these mechanisms for a number of reasons we could get into. They're failing when the president vetoes those attempts. And members of Congress are now, I think, very aware that they need to be taking the initiative to reform not only the authorizations to use force, the standing authorization, the 2001 AUMF that we were speaking about earlier, but also the War Powers Resolution that regulates instances where the president has not, in fact, acted on congressional authorization. And we've now seen, just in the last few months, a big act that does a lot of things, but for our purposes, the National Security Powers Act contains a series of reforms to the War Powers Resolution introduced by bipartisan members on both sides, in the House and the Senate, that work a lot of these reforms to correct some of the pathologies that we've seen in the War Powers Resolution. John and I testified recently on this. I know Professor Pearlstein has as well, and we can get into more of that later, but that can be kind of a bookmark for the beginning of the conversation.
Well, that's great. And it actually is a fine way to set up the conversation, which I hope, I want to turn to international law to some extent, but understanding the source of domestic authorization here is pretty important because it helps us understand the relationship between domestic law and international law, at least as incorporated in the US system. So John, let me actually back up. Tess has brought up there was this major authorization for use of military force in 2001, a statute authorizing use of military force in Iraq that was passed in 2002. But the early years in the Bush administration, immediately following the attack, are this series of legal innovations, not only this major sets of legislation that are passed, these among others. There's a mammoth detention program that's set up, run by the United States at its height in Afghanistan, in Iraq, in Guantanamo, maybe most famously detaining tens of thousands of people. Guantanamo only ever sort of a tiny fraction of that, but sort of a global detention system that's underway, a global in that respect as well, interrogation system, the creation of military commission trials for terrorist suspects as opposed to standard criminal courts. There are these critical sets of decisions that are made in the early Bush administration. Number one, that the response that what Al-Qaeda has done on 9/11, although Al-Qaeda has attacked the United States before, the USS Cole, the US embassies in Africa in the years immediately leading up to the attacks of 9/11, and those are dealt with as matters for the FBI, as subjects of criminal investigation. This is a matter of war, and the United States is going to respond that way. And then whether a debate inside the administration in the early days, whether the United States is going to recognize and apply the existing laws of war that traditionally apply, or at least in the post-World War II era, the United States has applied as a matter of course to its conflicts. These are, codified in treaties like the Geneva Conventions and in other places. And there is a huge internal debate that goes on early in the Bush administration about whether those treaties, which are designed to, prevent deliberate targeting of civilians and prohibit torture and all other kinds of sort of humanitarian protections, whether those treaties appropriately, legally, and otherwise apply in this new conflict. So why was that a debate? What are sort of the internal currents in the Bush administration, the legal arguments and the legal conversations that are going on during these sort of fraught times?
Well, that's a lot to unpack there, Deborah.
Yes, and you've got 30 seconds. No, I'm just
Tess is thinking, gee, I'm not going to have to say anything for the next 40 minutes, but let me try to pick one or two of these. Look, at the biggest level, which I think is something that the students can think about, is how has the US government for the last 20 years, including early in the Bush administration through successive presidencies, treated the legal framework for dealing with terrorists around the world. Not ones that we find in sort of ones and twos here in the United States, where we can just go arrest them and try them, as you say, Deborah, in federal court. But after 9/11 and then subsequently, there were hundreds, thousands of members of Al-Qaeda and the Taliban who were captured in Afghanistan. And then this conflict with Al-Qaeda continued on during the Obama administration. So the Bush administration immediately made the decision that these are not just a bunch of criminals in Afghanistan who have violated federal criminal law, and we're going to send the police and we're going to arrest them and we're going to bring them back and try them in the Southern District of New York. We're going to treat this as a war, an armed conflict with Al-Qaeda and the Taliban. Now, this was initially extremely controversial, particularly amongst human rights groups who didn't like the idea of this being sort of a war on terrorists. But let me unpack this a little bit. For one thing, and this was a question I got a lot from Europeans when I was State Department legal advisor, well, why didn't you just treat all these people as criminal suspects? If you thought they'd done something wrong, bring them back, try them. Well, in part, many of the people in Afghanistan who were captured by our military were not subject to our federal criminal laws. U.S. federal criminal law at the time of 9/11 did not apply extraterritorially to actions by foreigners unless they'd actually taken an action. So for the hundreds of members of Al-Qaeda from 30 or 40 different countries who had gone to train in Al-Qaeda training camps in Afghanistan and who were clearly up to no good, but maybe had not launched an attack yet, our federal criminal laws, they couldn't be prosecuted. Now, some of their defense lawyers cleverly said, well, therefore, they've done nothing wrong. Well, I suppose that means that's right. They've done nothing wrong and that they had not violated U.S. criminal law. But that was only because at the time, Congress had not anticipated that we would have to apply extraterritorially to the actions of people around the world. There's been a much backfilling both in the United States and almost every country in the world to apply their laws extraterritorially to reach people outside. But for the last 20 years, we've essentially had a armed conflict with Al-Qaeda and affiliated groups. And what that has meant was that the legal construct has meant that the individuals we could use military force against them. They could be detained indefinitely until the end of the conflict. We could launch drone strikes against them. And so essentially it was a military conflict. That was controversial during the Bush administration, although interestingly, it was then continued for the 8 years of the Obama administration and then through the Trump administration. As Tess knows, and she was in the middle of this, as were you, Deborah, from the outside, many critics of Bush administration thought that when the Obama administration came in, we were going to go back to what you called, Deborah, the law enforcement model. We would stop treating terrorism as a war or an armed conflict, and that we would only apply federal criminal laws. But instead, President Obama continued to treat it as an armed conflict with Al-Qaeda, and in fact, rather than detaining people, launching hundreds of drone strikes against individual Al-Qaeda members in a number of different countries. So I'll just say, and then I'll quickly answer your question on the Geneva Conventions and then turn it over to Tess. So one of the big picture issues legally is what is the appropriate legal framework to deal with terrorists who attack you from outside your country. And the United States has essentially for 20 years treated it as an armed conflict with Al-Qaeda and other terrorist groups. A controversial decision made early in the Bush administration, with which I disagreed internally, was if we were in an armed conflict with the Taliban and Al-Qaeda, do we therefore apply the traditional laws of war, which include the Geneva Conventions? And the Bush administration concluded that we would not, and there were legal reasons to do that, but some unfortunate policy consequences that fell from it. Indeed, the Geneva Conventions only apply between the contracting parties. It's not a one-sided convention. A country doesn't sign up to the Geneva Conventions and then say, well, whenever we're in a war, we will provide all of these protections. It's a contract between countries. Basically, countries in 1949 said, if we get into conflicts with each other, we will follow certain rules, including if we capture members of the other side, we will treat them as prisoners of war. The Bush administration concluded that, well, Al-Qaeda were a group of terrorists not representing any state who had not signed up to the Geneva Conventions. And the Taliban, although they were the government of a party, Afghanistan, they themselves had not followed any of the laws of war because they didn't wear uniforms or insignia or carry their arms openly or follow the laws of war. So the Bush administration concluded that the Geneva Conventions did not apply. And there are some good legal arguments for that, particularly with respect to Al-Qaeda, but it left the unfortunate position, which I had argued that I was concerned about when I was in the Situation Room at the time, that we would therefore be saying that we were in a war with Al-Qaeda and the Taliban, but that we were not applying either domestic criminal law, because it really didn't apply in most circumstances, or the traditional laws of war, because they didn't apply by their terms. And that opened us up in the Bush administration from critics to say, well, you are cherry picking amongst the laws of war. You are using it as a sword, but with no actual protections for anyone. You will put these people in a legal black hole. So now, interestingly, and toss this last one to Tess, is actually the Obama administration did not change anything there. Everybody expected they would come in and say, okay, we're going to treat the Taliban and Al-Qaeda as either prisoners of war under the Geneva Conventions or as protected civilians. but they did not actually come in and say that we're going to apply the Geneva Conventions as a whole to either the Taliban or Al-Qaeda.
Great. That's a remarkable job of talking about my enormously broad question and about a decade worth of legal developments. Tess, so part of what hinged on the distinction between the sort of criminal law model and the law of armed conflict model is this notion that under the law of armed conflict, it is lawful to target people, to lethally target people on the basis of their status. Are you a member of this army, of this military, of this armed group? If so, you can be killed. And you can be detained for the duration of the armed conflict, whereas obviously in a criminal law or standard sort of human rights law setting, there has to be some reason, some imminent threat that might justify law enforcement use of force, and people can only be detained pending criminal trial and charge. Enormously consequential sort of decision hinging, or consequences hinging on that decision. Is that the right decision initially? And what do you say to John's sort of characterization of, Obama largely embraces this, the Obama administration largely embraces this view? What changes, what stays the same?
Yeah, I personally think it was not the right decision initially, and I think that's potentially a 3-hour-long conversation that we can all have. But once that initial decision has been made, there's a range of authorities that become available, both in terms of international law and domestic law, in prosecuting an armed conflict to do things that would not be lawful during peacetime. And you just named the two big ones: status-based targeting. You can kill enemy soldiers or civilians while directly participating in hostilities, and detention until the cessation of active hostilities in a preventive manner, right? The point John made is absolutely right. You don't have to have committed a crime to be detained in armed conflict. You're detained based on your status as a combatant. The wrinkle, though, to all of these things is those become options, but they're not requirements, right? So the idea that you're in an armed conflict does not mean that one has to engage in a certain amount of status-based targeting or detain at all, right? So the United States is currently considers itself to be in an armed conflict, say with AQAP, Al-Qaeda in the Arabian Peninsula and Yemen, or Al-Shabaab in Somalia, or ISIS in Iraq and Syria, all throughout since 2014. That doesn't mean it needs to engage in detention operations in any of those places, nor is there a certain targeting tempo that's required. So even within this armed conflict paradigm, I think it's possible to kind of ratchet back. And that is essentially what I think Obama tried to do in some respects. So he did, I agree, have it in front of him as an option to revert to the law enforcement paradigm and international human rights law, and use also intelligence and diplomatic tools, et cetera. It's not just law enforcement. But he did have it as an option to get off of the war footing, and he talked about wanting to get off of the war footing. Instead, I think he did two things. He tried to ratchet it back. I think in other ways he ended up expanding it. But he also tried, I think, to tether it more to international law. So to some of John's points, and I think it's right that arguably as a formal legal matter, those detained in the early days of what the Bush administration was calling the global war on terror, that later became, under the Obama administration, the armed conflict against Al-Qaeda, the Taliban, and associated forces. Again, that's part of the trying to tether it to international law point there. We can get into that more in a minute. The question of formal POW status is maybe a little bit of a red herring, because there are other rules in the law of armed conflict, or IHL, as some of us call it, international humanitarian law. Those are pretty interchangeable. There are other rules that apply to conflicts that are not the ones John described between high contracting parties, between two states, but that apply in non-international armed conflicts, or as Common Article 3 of the Geneva Conventions calls them, right? They're conflicts not of an international character. And those are the kind of basic rules that that Deborah, you were referring to earlier: humane treatment of detainees, not deliberately targeting civilians. There There are a range of others as well that are not in Common Article 3, but that are considered customary international law in non-international armed conflicts. The NIAC is the term of art for that. And the conflict with Al-Qaeda and with the Taliban, once it fell from power and was no longer a state, was certainly not the first NIAC that the United States or other states were involved in, but it became kind of this, the most difficult one because of this issue of who the enemy was, right? So this wasn't a typical civil war, nor was it even a conflict where each party is vying for certain territory or trying to wrest the other from political control of a country, right? It's not a liberation movement. It's not an insurrection or an uprising. This type of transnational, non-international armed conflict did look new in a lot of ways. So the question of how particular laws applied was difficult, but I think it's important to step back and say that that doesn't mean that the laws aren't applicable. It means we have to wrestle with looking at exactly how to apply them. And that, I think, is one of the big differences between how some in the Bush administration, not everyone, but some in the Bush administration were asking themselves, it's difficult to apply the laws, let's not do it, right? As opposed to let's figure out how these laws apply. There's also, I think, a tendency to think about, you know, kind of an on-off switch between war and crime. I think it's important to recognize that in the entire post 9/11 period, our federal courts were open and were operating, and we're trying loads of terrorism-related cases, including, you know, more than 100 of people who were captured abroad, including someone who's currently serving a life sentence as the so-called 20th hijacker, Zechariah Moussaoui. So even though some of those who were directly responsible for the 9/11 attacks are languishing in Guantanamo without having been tried because of the failures of the military commission system, you did have our federal courts open and operating. And that's another way in which this, I think, can be distinguished a little bit from a traditional civil war, where your territory is you know, where it's impractical to be operating civilian courts. Here, I think we have the opposite. It's the military commissions that have proved impracticable, and it's the federal courts that have been able to continue to try even those who were, in fact, responsible for 9/11 in a way that actually secures convictions. So there's a really important set of questions about these trade-offs between which model to choose. But even once the choice was made to be on the war footing, it didn't take the law enforcement paradigm out of the picture entirely. But it did, I think, and we can get into this, but it's another conversation, so I'll stop here. It did make it harder to switch back. Once you had troops on the ground in Afghanistan, once you had detainees who were being held without charge because they had committed no crime, you have to let them go if you get off the war footing, right? You have to stop status-based killing. And that I think is something that was more difficult to turn around. That ship, you know, was a bigger ship to turn for the Obama administration than I think even he had anticipated coming in with some of the pronouncements he'd made about how he wanted to correct for some of the oversteps of the Bush administration.
So let me come in on this because I think it.
Oh yeah, please go ahead, John.
I think it kind of fits with kind of the bookends of where we are in Afghanistan, because we've heard a lot of talk, and probably many people listening here, you know, heard President Biden and others talk about, well, we have to end the forever wars, which I get. Having been there at the beginning of the forever wars, 20 years later, you know, I would not have thought we would still have been in Afghanistan and fighting these wars. You know, putting Iraq aside, which I think was a mistake, I think people have gotten so tired of Iraq and Afghanistan that there have been suggestions that, well, you know, it was a mistake ever to go into Afghanistan. That I have to really strongly disagree with. I cannot imagine that any Republican or Democratic president faced with 3,000 deaths on the day of 9/11 and knowing that the perpetrators were there in Afghanistan and that the Taliban were protecting them, to have done nothing about it. And, you know, for the same reason that just last week that, that President Biden basically said, we will hunt you down and we will get you, and launched drone strikes against people who were threatening US troops in Afghanistan. You know, there really was no alternative to going into Afghanistan in October. And it had to be a military operation. We didn't go and drop in 5,000 of New York's finest police officers to go and question people and ask them who they were and handcuff them and put what they had in their pockets in little evidence bags. I mean, it was a military operation, and the military was rooting out the Taliban, rooting out Al Qaeda, trying to track down Osama bin Laden himself. The war went on too long, as the British and then the Russians found in Afghanistan. It's not an easy place to stay. But I don't think there really was a choice back in October 2001, either to go into Afghanistan to root out the people who had attacked us, or to treat that originally as a military operation. I certainly have not been comfortable, and I wasn't comfortable way back in the Bush administration having long-term detention. But it just wouldn't have really worked any other way. We could not have gone in to Afghanistan and basically said, well, if you find somebody in a cave in Afghanistan and you can't immediately conclude that they're a suspect in a crime, then you've got to let them go. It was a major military operation conducted by our military under the laws of war. Did the subsequent knock-on effects of long-term detention and so forth work out well? No, they did not. No, I disagreed with a number of these decisions as we kind of made them along the way. But to the some, and Deborah, you know this very well, some human rights groups at the beginning suggested that this should only have been treated as a law enforcement operation, that these were terrorists who had attacked us, and all we needed to do was, obviously we couldn't have just sent in extradition requests to the Taliban to say, please go find these people, arrest them, and send them to us, and we will try them. So, and the American people would not have stood knowing, that the perpetrators were in Afghanistan for us to have done nothing. So, have things worked out well over 20 years? I'm not going to defend 20 years of every decision of subsequent presidents, but it was a difficult decision back after 9/11 in September, October of 2001.
No, and you don't need to defend the last 20, all of the policy choices of the last 20 years, certainly not. But I do want to pick up on this piece of the sort of innovation in the application of the law. So if the early Bush administration view is, well, this is like war, but this isn't a state, so the existing apparatus of international law regulating, applying humanitarian protections in war doesn't really apply at all, to this move driven in part by the Hamdan decision by the Supreme Court in 2006 and other pressure that is ultimately embraced then by the Obama administration to say, well, no, it does apply. That body of law recognizes two different kinds of conflicts between states and conflicts not between states. And this is a conflict not between states, and the law applies to that extent. But the end of the Bush administration and the Obama administration used that, as Tess was suggesting, use that model in a new way, right? Instead of saying this is a civil war, a state actor versus an insurgent group within that state, this is a civil war within Afghanistan now, right? The Obama administration embraces it to say, consistent with the Bush administration view, this is a global non-state armed conflict, right? It's a conflict between a state and non-state groups, but it is happening everywhere. And on that basis, we can use armed force, not just in Afghanistan, but also lawfully within the same scope of the same armed conflict under international law in Yemen, in Somalia, in Libya, in Syria, and beyond. And it seems to be that view that was embraced also by the Trump administration, as far as I can tell, and seems to be so far embraced by the Biden administration, although we're sort of waiting for a more definitive statement of what the legal view is. Is that view, the idea that there is such a thing as a war under international law that has no geographic boundaries, right? And that these war rule applies, these rules about lethal targeting and detention till the end of the conflict, is that view, in your view, consistent with international law? I'm asking both of you, right, to comment on that. So far, I don't think that any other nation in the world has sort of joined us in embracing that construction of the law of armed conflict. Is that a mistaken construction? Is it problematic? Is it concerning, or is it necessary given where we are in the nature of transnational terrorism threats in the world? How do we sort of deal with that in the face of the law that we have had? Either one of you can.
I can take a quick stab at it, and would really love to hear John's thoughts on that too. I mean, it is a deeply controversial view, and it's one that has been, as you say, contested even by our closest allies. It's one that has driven us, I think, to think about the armed conflict that we say we're waging in ways that are more constrained than might otherwise be allowed. So when you think about what the PPG did, and this is I'm going to try to bracket a very long conversation here, but rules on targeting in these places beyond Afghanistan, right? But where we say the war follows the fighters.
This policy
Somalia,
guidance,
Libya, Yemen, et cetera, right? There was a presidential policy document that was intended to kind of put rules around that. And if you look at it really, really closely, one way to think about it is that we were bringing it a little bit closer, bringing the targeting paradigm a little bit closer to making an initial use ad bellum determination every time. And the short way to describe that is there's an initial determination as to whether the use of force is lawful at all vis-a-vis another party, and that's the resort to war, whether it's lawful to use armed force in the first instance. Then once you're in an armed conflict, fair game to use force against the other side, subject to the rules about all of the IHL rules that we've discussed some of before. The decision to get a little bit closer to almost asking that initial use ad bellum question every time does not match with the US view of once you're in a war, you can essentially take these strikes as long as you have either the consent of the host state or what kind of later arose is the so-called unable or unwilling test, which we can bracket for now. But that I think looks more like what our closest allies would have done in these situations, is to say, all right, with these groups in this other place, these other fighters or these same fighters potentially who've moved to a different place, can we lawfully resort to the use of armed force there and against these particular actors? So you see a little bit of that blurring that I think is driven in part by a humanitarian concern to not have to not have civilian casualties, even up to the amount that the U.S. would have thought the law of war allows, but also I think partly out of a desire to mesh the U.S. legal view of the conflict, which was a bit of an outlier, with those of some of its closest allies. And so there is a real concern for how those we work in partnership with, as well as those who might want to distance themselves from us if we behave too far outside of the pale of the mainstream legal thinking, to kind of mesh our views with theirs, even while preserving our view of what the law was. I say "our" referring to the U.S. government. I do differ in some places with the views that the Obama administration took, but I also think there's and to go back to your question about the global nature of the war, there is, I think, a little bit of a reason to hope right now that there could be a kind of ratcheting back of a little of that with the Biden administration having not taken its most recent strikes in Iraq and Syria under the 2001 or 2002 AUMFs, instead relying on his Article 2 power under the Constitution. I think there's probably more domestic law driving that than international law. But part of what it's saying is that this isn't, in fact, part of the same armed conflict. When we are looking at a group that seems to potentially be related to another terrorist group that's threatening the United States or is taking strikes against us, it doesn't necessarily always mean it's part of the same global armed conflict. We can, in fact, draw boundaries around it and say it exists over there, and there's this other threat over here. And I think that's a potentially encouraging sign that this doesn't have to just metastasize forever into a bigger and bigger armed conflict with all terrorists everywhere.
Great. So John, let me ask you to respond in any way you want, then I'll see if I can get a question in.
Sure. In my answer, I'll actually address a couple of the questions that have appeared in the chats, which are good questions, or in the Q&A. So one, just so everybody who hasn't been following it knows, as both of you have said, it has been controversial for 20 years for the successive administrations to say that our conflict, even with Al-Qaeda and affiliated groups, is not just going on in one country, but is going on all around the world. And therefore, to have successive administrations, Bush, Obama, Trump, as you say, we're not clear what President Biden will do, but I think probably will follow to a certain extent, say, that if terrorist groups related to Al-Qaeda are attacking us from different countries around the world, that we are in conflict with them, not just in Afghanistan, but in different places. And that has been troubling to our allies. And I used to get, when I was State Department legal advisor, talking with our allies, they would say, well, what is the limiting principle here? Are you saying that you could shoot people on the streets of London if you saw an Al-Qaeda person? Now, I had a good answer to that, which was, no, of course not. 192 of the 196 countries in the world or so are perfectly capable of dealing, with Al-Qaeda in their countries. And we can go to them and ask them to go and arrest somebody. But there are a number of ungoverned places like Yemen and Somalia and Afghanistan where there was no functioning government, and that the only way, this is why President Obama dropped drones on so many terrorists in so many different countries, because there really was no other way to address the threat. Let me just address the two questions in the chat, and then we'll help you end it up. One, someone asked, well, even if the Geneva Conventions don't apply, surely some customary international law must apply. And that's right. The problem is there's just not a lot of customary international law in what we call a non-international armed conflict, a conflict between a state and non-state groups. Again, I got this question a lot of saying, well, if the third Geneva Convention doesn't apply and the fourth Geneva Convention doesn't apply, well, you have to apply customary international law principles. And we would say, yes, but there's just not a lot. And the ICRC a few years ago conducted a major effort to determine what law applies, particularly to detention in international armed conflicts. And the president of the ICRC at the time, Jacob Kellenberger, said there are indisputably gaps in customary international law, but in trying to get states to agree on how to fill those gaps, they just couldn't get them filled. So there still are gaps in customary international law on detention. And then finally, to our mutual friend, all three of us, Gabor Rona from Human Rights First, who's been working on these issues for decades. He asks, well, if President Obama didn't apply the Geneva Conventions, but the US government position going back decades has been that our human rights treaty obligations apply only on the territory of the United States and are not carried by our soldiers, so to speak, in their backpacks, so that human rights obligations apply everywhere there's a soldier in conflict, then what law would apply? And I think that's a fair question, Gabor. I do think that the U.S. was left in a difficult position in this conflict with Al-Qaeda around the world if not a lot of international law applied. they're due to this day, 20 years later. And as you all know, I've been writing about this for quite some time, is we need to work harder to fill these gaps in international law. And I think it frankly is something that the Biden administration could pick up. The US has always been a leader in developing international law, particularly international humanitarian law, often after a war. And this would be a time with the credibility of the Biden administration to try to fill some of these gaps through US leadership.
So Tess, I know you've got a hard stop. You can address any of that or none, but let you have the last word.
Sure, thanks. I think one small point is that even under the Bush administration, there was an acknowledgement that some aspects of international human rights law, some of our IHRL obligations do apply extraterritorially. And I think one example, John, that I might credit you for is the acknowledgement that the prohibition on using statements obtained from torture in any proceedings applied at the ARBs at Guantanamo. And the Obama administration, of course, continued that view that that obligation applies extraterritorially. Of course, there are similar obligations on IHL. But I think, that's similar to the point about not necessarily always having to choose either war model or crime model. It's not necessarily an on-off switch with our international human rights obligations. Some have long been acknowledged to apply extraterritorially. And I think this question of gap filling, it's a really important one, but I do think the first exercise is always trying to decide, and this is something that comes up a lot with questions about, say, cyber conflict or other novel forms of warfare. Let's take another look at the laws that are already on the books and make sure we don't think that there is actually a way that they do apply here, because I think often the answer is to go back to the legal frameworks that we have. But to John's really good point, I too would exhort the Biden administration to take up that task. But if it's truly going to do it in hindsight, which, as John mentions, may be more effective, it's got to end those forever wars first and close Guantanamo. So if it succeeds in winding those things down, then John, I hope you can join in helping lead the effort to pick that Herculean task up moving forward.
So to the students who all have
years in the Bush administration to try to get Guantanamo closed, and supported you all in the Biden administration or the Obama administration to get it closed. Unfortunately, our Congress has passed laws that make it difficult. So Tess, I'll have to leave it to you at Just Security to write the blog post that tells the Biden administration how they can close Guantanamo over laws passed by Congress.
You couldn't have advertised better, John, for our piece coming out tomorrow by Ian Moss, who knows this issue better than anyone, on exactly how to do that. So stay tuned.
So students can find that piece at Just Security tomorrow. Google Just Security, it will show up. And students have your work cut out for you in the years ahead. My international law students will hear more about these issues in detail when we introduce international humanitarian law and these other topics in a few weeks' time. In the meantime, thank you so much, John and Tess, for covering so much ground in such a short period of time and for doing it in such a rich and interesting way. Thank you again, and I hope you're always welcome at Cardozo. Thank you all, and thank you all for joining us, everyone. Goodbye.